Hello and welcome to today's webinar on lifetime allowance protection. My name's Lisa Webster and I'm Senior Technical Consultant here at AJ Bell. So on the agenda today then, I'm going to start off by looking at just the basics of lifetime allowance. Then I'll move on to look at the different types of protection in turn, and then on to the various enhancement factors that you can get to lifetime allowance. And then I'll get into sort of how the protections are used with a few case studies and things. And I'll finish off with some of the more complicated bits of the interactions between different types of protection and how that works in practice. So we're going to start off then with the lifetime allowance basics. I'm not going to go into too much detail on this. A colleague of mine, Rachel Vey, did a webinar on this a few weeks ago, looking at the lifetime allowance in a lot more detail in terms of benefit crystallization events and how it's tested against, how at those events you're tested against the lifetime allowance. So, you know, if you want any more information about that, if you haven't seen the webinar already, that is available on the Investcentre website in the Infocenter videos section. So, yeah, by all means, go back and have a look at that if that's what you're looking for. But for now, I'm just going to say a quick recap of the basics and then move on to protections. So the lifetime allowance then, basically, it's an amount of money that you can take from your pensions in your lifetime before the lifetime allowance tax charge applies, the LTA tax charge. You're tested against the LTA, generally speaking, when you access benefits, and there's a couple of other occasions as well. So the obvious ones are things like taking PCLS, pension commencement lump sum, designating funds for taking income, annuity, starting a scheme pension, but also things like age 75, certain circumstances on death and limited circumstances for scheme pension increases. Those are the events when you get tested, but I say it's more about those in detail in Rachel's webinar. And if you exceed your available lifetime allowance across all pension funds, then there is a tax charge on the excess. And again, how that tax charge works is something that Rachel's covered in hers. So I won't be touching on that one today. But the basic concept of the lifetime allowance was introduced at A-Day, so it came in on 6th of April 2015. And this is what's happened to it over time. So when it was introduced, it was set at £1.5 million. It came in as part of all the A-Day changes, but all those changes were contained, most of the legislation on that was in the Finance Act 04, and that piece of legislation actually set the lifetime allowance for the first 5 years. So we knew in advance what the lifetime allowance was going to be, and it nicely went up every year from £1.5 million, rising all the way to £1.8 million in 2010-11 tax year. Which was great. So we hadn't had a lifetime allowance prior to that, but the fact, you know, it was at quite a reasonable level and it was always going up. And actually, that FA 04 actually stated that the lifetime allowance wasn't going to be allowed to go down. As we all know, laws can be changed, and obviously that is what's happened with the lifetime allowance. So the first idea of protection came in with the lifetime allowance back in 2006, and the idea of the protection then was to protect those people who had built up pension benefits before this concept of a lifetime allowance, this lifetime limit on how much you could have in your pension funds before tax, before this was introduced. So if they'd already built it up thinking, you know, they weren't going to have this charge, then they were protected against it, they weren't going to be hit by it. That's the sort of basic idea. Since then, whenever we've had a reduction in the lifetime allowance, then in a similar way, there's been protections introduced to protect those people who had built up pension funds on the basis that the lifetime allowance was going to be higher, because it was at the point that they were putting money into their pension, so that when there's a reduction coming along, they can still protect you know, what they've already saved. So on the first cut in the lifetime allowance in 2012, when it dropped back down to 1.5 million, we had some protection then. It was cut down to 1.25 million in 2014. We had another load of protection then. And then in 2016, we had our most recent cut down to 1 million. And no surprise, another load of protection then. The lifetime allowance stayed the same for a year. And then we have seen, we are now slightly going in the right direction. We have CPI increases each year based on the September CPI figure. So it is creeping back up, but I think it's going to take us a long time to get back up to those 1.8 million levels. So getting into protections then, we have, as you see, at sort of different times when protections have been introduced, and we have a number of different types. So we have the originals, we have the A-day protections that came in. So primary protection and enhanced protection. And then I've also put on here scheme specific. Now, scheme specific doesn't actually protect you from a lifetime allowance charge, but it is have an impact obviously on the lump sum that you can take out. So I'll have a look at that as well, because it all kind of interacts with the other forms of protection as well. Then we have the new kids, the newer versions of protection. So we have 3 different types of fixed protection, and we have 2 different types of individual protection. And alongside all of that, we have enhancement factors. So the concept of enhancement factors came in with the lifetime allowance back in 2006, but you can get those at any point in time. So I'll have a little look at those and how they work as we go through. So I'm going to start off by looking at each of them in turn, just sort of an overview of how each one of them works. So for primary protection, you had to have pension rights at A-day, back on the day before, technically, 5th of April 2006, you had to have pension rights of at least £1.5 million, which was the level of the lifetime allowance when it was introduced. You received an enhancement factor to your personal lifetime allowance, depending on the amount of savings you had above the standard 1.5 million. Still allowed to make contributions, was the good news on primary protection, so you can still put money in, but obviously if you're making contributions, particularly if you're making substantial contributions, then your growth, depending on how well your fund grows, then it might take you above your protected level for your personal lifetime allowance. But yeah, you do still have that ability. In terms of your pension commencement lump sum, you can have, at outset, it was just a straightforward 25% of 1.5 million. And it did go up every year when the lifetime allowance was going up. So you would have a pension commencement lump sum maximum of 25% of whatever the standard lifetime allowance was. But since the lifetime allowance dropped below 1.5 million, then it is now fixed at 1.5 million. If we ever get to a level when the standard lifetime allowance is higher than that, then it'll be whatever the standard is. This is, of course, if you don't have lump sum protection with your primary, which I'll look at a moment. This is just somebody who just has primary protection. You can't revoke primary protection. So once you've got it, you've got it. It doesn't matter, say, making contributions. You can't write to HMRC and say, I don't want it anymore. The only sort of caveat on that, hence the asterisk, is that you can lose it on divorce, which I'm not going to go into a lot of detail about that today, because my next webinar I'm talking about is divorce, and I will cover it in that one, the sort of, amongst many other aspects of pensions and divorce. I will also cover the impact on protections, but we've got enough in here for today, so I'll leave that one till later. And you had until the 5th of April 2009, so 3 years, basically from when the rules came in, to apply for primary protection. So a quick example of how it would work, how you would get your enhancement factor. So if you have somebody who had pension rights on the 5th of April 2006 of 1.7 million, basically you would take the excess of their rights above the newly introduced lifetime allowance, divided by the lifetime allowance, and that gives you the factor. So here, if it's 1.75 million, you take away 1.5 million, divided by 1.5 million, you have an enhancement additional lifetime allowance factor of 0.17. That figure is always rounded to 2 decimal places, and it's always rounded up. So, even if you had 1.61, you still round it up to 1.7 on that one. Moving on to enhanced protection then. In a lot of ways, it's a lot simpler. You didn't have to have any minimum amount on A-day, minimum fund value at A-day. So yeah, anybody could have it, but of course the big caveat with enhanced protection is that you can't have any further contributions or relevant benefit accrual under a DB scheme. So it does limit you in that respect. Your PCLS, similar to with primary, is limited to 25% of 1.5 million or standard lifetime allowance if that ever gets to be higher again. You can revoke enhanced protection. So obviously making a contribution is one way of revoking it. You can just write to HMRC. And the deadline for this was the same as with primary protection back on 5th of April 2009. Enhanced protection really is the top trumps of protection. It's the only one that if you hold it, and as long as it's in place when you crystallise benefits, when you have your VCEs, then you cannot have a lifetime allowance charge if you have enhanced protection in place. Maybe limit some things on PCLS, but you can't have a lifetime allowance charge. So in that sense, yes, you're limited in terms of how you build benefits up, but in terms of when it comes to taking benefits, yeah, it can't be beaten. Enhanced protection is the best kind. Also at A-Day, we had this concept of scheme-specific lump sum protection. So enhanced and primary protection cover all your pension benefits. So however many pension schemes people have built rights up in, it covers all of them. As the name suggests on this is specific to one pension scheme. So if your lump sum rights within a scheme were more than 25% of the pension rights at A-Day, then you would get this kind of protection. It's automatic. There was no need to claim it from HMRC. So it would be the scheme administrator of the relevant scheme that would have the details on this. You didn't need to have a huge pension fund. You could have somebody who had £100,000 in pension, but they had £40,000 was payable as a lump sum. Obviously, that's more than 25% of the fund, so they would still be able to claim this. Do have to be very careful with transfers. Generally, it is lost on transfer, so you need to take it from the original scheme. There are these block transfer rules, I'm sure a lot of you will be familiar with, that if you want to transfer it, you need to transfer it with somebody else from that scheme to the same new scheme. A few more criteria on that as well, but yeah, just careful on these ones. These are always expressed as a monetary amount, so it's not that you have 30% of your rights. It would be said, if you had £100,000 with £30,000 PCLS, it would be expressed as £30,000 at A-Day, as that is your protected lump sum. Important point to remember as well with these is that if you have a scheme-specific lump sum, you have to take all your benefits from that scheme at the same time. You can't do a partial crystallisation. You would lose it. Doesn't mean you have to take them from all schemes at the same time, but from the scheme that holds this protection, you have to take it. It's all or nothing, or you would lose the right to the enhanced lump sum. Moving on then to combining either primary or enhanced with a lump sum protection. So the other one was scheme specific. This one, if you have it with primary, this is across all your pension schemes. So if your total lump sum rights at A-Day were more than £375,000 and you had primary protection, which means your whole fund would be more than 1.5 million, then you could have primary with lump sum protection. That would be expressed as a monetary amount, and that would be on the certificate that you get from HMRC, which would say, yeah, whole primary protection with X amount lump sum, protected lump sum as well. When you have enhanced protection, it works differently. Again, the criteria is the same. You just have to have lump sum rights at A-Day of above £375,000, but this will be expressed as a percentage. You could have people who had a very large pension fund who applied for enhanced protection, and their lump sum might only be 20%. But because it's above the £375,000, they would still have it. And again, that percentage would be expressed on their protection certificate from HMRC. If somebody had this sort of primary protection, lump sum protection, and because of their overall rights, and then they had in a particular scheme, they had a scheme specific lump sum protection that was automatic as well, the primary protection with the lump sum protection would take precedence over it. Moving on now to the new forms of protection then, quick overview of these, a little bit more straightforward really. For fixed protection then, we had 3 versions of these. So the first one came along in 2012, and at the time it was just called fixed protection, didn't have the year after it because it was the only one of its kind. But then as we've had new ones introduced, we now have fixed protection 2014, FB14, fixed protection 2016. With these, there was no minimum fund value. So again, anybody can apply for it, but no further contributions or relevant benefit accruals. So it's a bit like a poor relation to enhanced protection, in that anybody can have it, no minimum fund, say no further contributions, but unlike enhanced where the whole fund is protected, with fixed protection, it's still a limited protection. So, and the level of protection will depend on which version that was taken out. So that's 1.8, 1.5. It's basically you're protected at the level that the LTA was at the date the protection came in, before the next drop. The first 2 forms of it, the application deadlines have passed. Basically, you had to apply by the date of the drop in the lifetime allowance. But fixed protection 2016 is a bit different because they haven't actually put a deadline on it. So even though we're 4 and a bit years past it now, you can still apply for fixed protection. But of course, in practical terms, what will stop a lot of people being able to is the fact that you can't have made any contributions on or after 6th of April 2016, which, you know, obviously most people will have done, especially with auto enrolment and things. But, you know, if you do come across a client that would benefit from some level of protection and hasn't made any contributions in the last 4 and a bit years, and doesn't intend to, then it could still be, you know, it is still open, it is still possible to apply for those. And the final one that we have is individual protections. So it didn't come in with fixed protection in 2012. It came in alongside the 2014 and 2016 versions of fixed protection. We also had individual protection in those years. And if primary protection is like the poor relation, sorry. If fixed protection is like the poor relative of enhanced protection, and then individual protection is like the poor relative of primary protection, I think. You have to have funds valued above the standard lifetime allowance at the relevant date. So for individual protection 2014, which was when the lifetime allowance dropped from 1.5 million down to 1.25, then you had to have above 1.25, but the maximum level would have been the 1.5, which was the previous level of the lifetime allowance. So you do get an individual amount. So people that have these protections, you know, it'll have their fund value written on it, which will be a specific amount individual to that person. So they will all be different. Like primary protection, you can make further contributions to it. It doesn't cover all of your fund. You can make further contributions. Obviously, the more you contribute, the more you're likely to go above your protected level. And similarly, you can't revoke primary protection. You can't revoke individual protection, but you can lose it on divorce in a similar fashion. It's also possible to hold more than one form of protection at a time. This is just sort of showing you the combinations available. So the most common one at A-Day was certainly for people to have primary and enhanced together. That was very common for those that had a fund of above 1.5 million. And when you had that, you would have enhanced protection with dormant primary protection, and that's what would be written on the certificate. And you would only use your primary protection if you revoked the enhanced, which there are circumstances when you would want to do that, which I shall be looking at shortly. And then, a bit more complicated this one, but more similarly here, that you can have individual protection dormant to either enhanced protection or any of the fixed protections. And it's generally the enhanced and the fixed protections are the better ones, if you like, give you a high level of protection. But particularly, if you make contributions or anything, whether it's deliberately or accidentally, then the other ones give you some protection. The primary or the individual gives you something to fall back on. So just to sort of summarise sort of the application process, evidence what you get on it for the informs of protection then. Everything was done sort of by paper, sending forms off to HMRC prior to 2014. It was a paper-based process. For the most recent ones, which are still open, the 16 versions, 2016 versions, that is all done online now. The deadlines for all the old ones have passed, I say, apart from 2016, which is still available at the moment. I'm going to come back to late applications shortly, but just the certificates, looking at the next column. So when it was a paper-based process for applying to HMRC, you will get a certificate back from that. So clients that have taken out any of these forms of protection should have certificates, which when the time comes, they can show that to their pension scheme administrator so they can use those protections. I say if somebody had enhanced for dormant primary, it'll be written on the certificate, it'll state that. For somebody that has FP, say if you have fixed protection 14, say with individual protection 14 dormant, it doesn't actually state that on the certificates. They've done it slightly differently. It will just say fixed protection, but HMRC will have a record of it. So if you revoke that fixed protection, they will then send you a new certificate stating that you have individual protection. So that is slightly differently. With the primary enhanced protection, you say you could have lump sum protection as well. If that was the case, it will be stated on the certificate. With fixed and individual protection, there's no option for having lump sum protection as well. It'll just be the PCLS will be 25% of whatever the protected amount is. And on the online forms, you just get a reference number issued, and then there's a lookup service for the scheme administrator to check that and check what the level of protection is on those ones. Just going back to late applications then, because there's been a few cases on this recently. There's a few tax tribunals where people with varying success have applied, let's say, late applications for maybe enhanced protection, but it was equally applied to primary protection as well. So there is provision for late applications relating to enhanced and primary protection. There are none for any of the fixed or individual protections. Obviously, it doesn't apply to the 2016 versions because we haven't got a deadline, so you can't be late for that one. But for the other versions, there's nothing similar. So for primary or enhanced protection, basically to be able to do a late application, the individual requires a reasonable excuse for not giving the notification by the closing date, which will be 2009, and then they have to complete the notification without unreasonable delay once the reasonable excuse has ceased. And if HMRC refused to consider the late application, then you can go through the tax tribunals, which is what has happened in a couple of cases. So one of them, the first one, which was Mr. Twait versus HMRC, in that case, it was agreed that there was a reasonable excuse for late notification. So this was where Mr. Twait had a serious health condition around the time of when he theoretically should have been making the applications, but the applications closed, and it was accepted that it was a reasonable excuse for him not to have gone through the process because he had other things to worry about. But then once the delay sort of was realised and himself improved, and he wanted to, and the need to apply for protection was identified, there was 11 months before the application was made. So that one failed on the second part. So he had a reasonable excuse for not giving the notification by the closing date, but he didn't have a reasonable excuse for the further delay once they'd realised they should have made the application. But there's a couple of other cases which were successful. Basically, there's Tipping versus HMRC and Jackson versus HMRC. And ultimately, the success of these cases boiled down to the fact that both the excuse for not applying by the deadline and the delay once the excuse had ceased were found to be the fault of the advisors involved, on whom the client had reasonably relied. I think one of those, there was basically the advisor had made a recommendation that the client applied for enhanced protection, and sort of gone through it, and the client thought he had enhanced protection, but the actual, it never it was an error in the office, I think, and basically the application form had never been sent off. So when they tried to find the application, when it came to take benefits, tried to find a certificate, didn't have any evidence of it. They looked through, and then it was only discovered at that point of time that he didn't actually have the protection. And then, then you make the application. So, you're probably not going to have many of these cases, but if you do ever have a client come to you that you think should have had the protection and hasn't, one of the original forms of protection, or because they weren't advised correctly in the past, or there was a mistake made in the past, it's not necessarily too late to make the application, but as soon as you've discovered it, you need to act pretty quickly and don't delay any further, or else you won't meet the second point in the criteria. Okay, moving on now to enhancement factors. So in fact, enhancement factors, I say, were introduced from A-Day along with the concept of the lifetime allowance. And there's certain circumstances where people can have a boost to their lifetime allowance. And these can be applied for at any time. So it's nothing to do with changes in the lifetime allowance over time or anything like that. They are specific to client circumstances. So there's 3 different ways of getting a lifetime allowance enhancement factor when they're given out. The first one is the pension credit factor. So this is basically on divorce, where somebody receives a pension credit since A-Day, and the pension was in payment at the time of the pension sharing order, and it came into payment post A-Day. So basically, in the hands of the original member, they've got their pension, they've started taking benefits from it after A-Day. So those benefits have already been tested against the lifetime allowance. If there's then a pension sharing order put in place and they're transferred to the ex-spouse, it just means it stops HMRC getting a second bite of the cherry of testing the same benefits twice because they're in different people's hands. Because, so as long as it's in payment and it came into payment post A-Day, then the person receiving that pension credit can apply for a pension credit factor in relation to them. The next one we have is the recognised overseas scheme transfer factor. So this is where you get a transfer in from ROPS, secure ROPS, to a UK registered pension scheme since A-Day. And that's basically because if pension funds have originated overseas, when they've got into that pension scheme, they won't have benefited from UK tax relief. Or even if you've had somebody who's built up pension benefits in the UK and they've transferred out to a cure ops and then they're transferring it back in again, which does happen, those benefits will have been tested on the way out of the UK system, because transferring to a cure ops is a BCE event. So that will already have been tested. So it doesn't get tested again on the way back in. So you can get a credit factor for that, enhancement factor, I should say, sorry. And then finally, we've got this non-residence factor. So this is somebody who's a member of a UK registered pension scheme, but not entitled to tax relief on their contributions going into it. So if they're a relevant overseas individual, any contributions they make will be non-tax relievable, or if their employer's putting into it, it could be, but they don't get tax relief on these, so they don't have the benefit of tax relief, and so therefore they can get a factor, enhancement factor for that as well. The way that works is to calculate the enhancement factor, it's the relevant amount, which for a pension credit factor will be the crystallised element of that pension credit. For a cure ops coming in, it's going to be the amount of the transfer less any UK tax relievable contributions made to that scheme, which is only going to happen in limited circumstances. Normally it'll be the full transfer value. And then, or for the non-residence factor, it'll be in relation to those years, the pension benefits built up in those years when they weren't a relevant UK individual, not getting tax relief on those. So you have that relevant amount, you divide it by the lifetime allowance in the tax year when you are acquiring this enhancement. So it's, whether it's the transfer in, whether it's the pension credit, pension sharing order coming in. So as an example then, if you had a pension credit coming in for £400,000 in this tax year, you would just divide that by the lifetime allowance this year to give you your enhancement factor. and this is always rounded up to 2 decimal places again. So in this example here, 0.3727 would be rounded up to 0.38. Just a little one here, if somebody has a fixed protection or individual protection, when you calculate the enhancement factor, it will be based on their individual lifetime allowance, not standard lifetime allowance. So for example, if somebody had fixed protection 2014, and again, the same thing, they got pension credit £400,000 in this tax year, you do £400,000 divided by 1.5 million, because that's their protected lifetime allowance, to work out the factor, the enhancement factor, because when you come to take benefits, you're going to be enhancing 1.5 million, not the standard lifetime allowance. So that one then is 0.267 in this example, which is rounds up to 0.27. There is a time limit for applying for enhancement factors, for your notifications to HMRC, and it's basically, well, the way they word it, it's 5 years after the 31st of January following the tax year whether it's pension sharing order or transfer or the non-residence factor took effect. So as an example, if somebody had a pension sharing order which was effective in the 2015-16 tax year, 31st of January following the tax year when it happened will be January 2017, and then you've got 5 years after that to apply for it. So that deadline would be the 31st of January 2022, and you would need to complete, it's the APSS 201 is the form that you need if it's a pension sharing order enhancement factor that you need. So you've got a little while there to get that across to HMRC. If you were doing a ROPS transfer in, if you did that this year, for example, so the 31st of January, the tax year following this tax year, is going to be January 22, and then you'd have 5 years from that. So you'd have 31st of January 2027 to complete your form. And the form that you need for both the ROPS transfers in and the non-resident, so for either international element, is the APSS 202. So I'm going to move on now to how we use the protections, with a few case studies, hopefully bring it a bit to life. I do realise it's a pretty dry subject, this one we're on today, so hopefully this will help it a little bit. So first of all, I'm going to look at using the primary protection. So the example that I used right at the start of how you calculate it, so I've just put that back up there again. So somebody pension rights 5th of April 2006 of 1.75 million, we worked out their lifetime allowance factor would be 0.17. When they come to take benefits, the enhancement factor is applied to the higher of the current lifetime allowance and 1.8 million. So that's because the 1.8 million is what's called the underpinned lifetime allowance. So this concept came into play when we had the first drop in lifetime allowance in 2012. Prior to that, your enhancement factor would always have been applied to the standard lifetime allowance. That's how rules were written for pension simplification coming in for A-Day. But obviously that was when we thought the lifetime allowance was only ever going to go up. So when that changed, they introduced this concept of this. So the idea is that when the lifetime allowance was dropped, then people aren't worse off than they would have been when it was at its highest, which was 1.8 million. So for primary protection, you always apply your enhancement factor to 1.8 million. So our individual here with his lifetime allowance factor of 0.17, if we apply that to 1.8 million, he gives him now, if he's taking benefits today, he has got a personal lifetime allowance of £2,106,000. However, there is a complication when it comes to reporting lifetime allowance, and this is one. It's a bit complicated, and it causes confusion. It's not something I particularly like personally, but scheme administrators, we have to report lifetime allowance usage, and for those with whole primary protection, we have to report it on the standard lifetime allowance, which doesn't seem to make an awful lot of sense. So we would have to report on somebody using the lifetime allowance based on, if it's this year, £1,073,100, not their protected amount, which does give some quite misleading information, I think, which has to be sent out to clients. So it's one that you just need to be aware of. So when people get it, they understand it and aren't alarmed by it, basically. I've got a case study in a minute, which will show you what I mean by that in a bit more detail on how it works. So we have this underpinned amount of 1.8 million, but that's not what we report on. And also, to complicate things further, I did mention this right at the start, if somebody doesn't have lump sum protection, the PCLS will be 25% of 1.5 million until the lifetime allowance gets higher, which just means we end up in a bit of a mess, really, and it just shows how complex lifetime allowance can be, because we have our enhancement factor applied to 1.8 million, and we report on the standard lifetime allowance, which is, you know, just over 1 million, and then we have lump sums based on 1.5 million. So we use 3 different figures for one client who has primary protection, which I think we'll probably all agree is less than ideal, and no wonder people get confused by it. But that's where it is. And basically, they decided with the first drop in 2012 to create this underpinned of 1.8 million. I don't know whether they just didn't think about PCLS. There were people that were worse off because of the restriction in PCLS after that drop in 2012, and then in 2014 they decided to underpin the PCLS, but then at a different level. So not ideal, really, but it is what it is, and we just have to work with it. So an example of this one, I'll put some numbers on it, hopefully makes it clearer. So primary protection in use. Here we have John, who's age 65. He's got a fund value of £2 million. We're going to keep the figures I had in the last slide. So he has a protected lifetime allowance of, his enhancement factor was 0.17, and so he has a protected lifetime allowance of £2,106,000. So he wants to come along now and fully crystallise his benefits. What can he do? How's it reported? His max PCLS, because he doesn't have any separate PCLS protection, will be 25% of 1.5 million we use when we're talking about PCLS. So he can have £375,000 PCLS. His drawdown fund then will be the difference between the two. So because he's got £2 million fund less his maximum PCLS. So that can all go into his drawdown fund, so £1,625,000. He can do that because he's within his protected lifetime allowance. His total fund value is below his protected LTA. If he was over, then he would have lifetime allowance charges, etc. But he's not, so that's fine. But when it comes to, so this is the bit which I think is a bit confusing, when it comes to lifetime allowance usage reporting, we have to report that as 2 million is the amount being crystallised over his lifetime allowance, the standard lifetime allowance, not over his protected lifetime allowance. So we would report that on 186%, with 37% of his lifetime allowance being used, which is, I say, slightly confusing, because he actually hasn't used 100% of his lifetime allowance. He's got a £2 million fund, he's got a lifetime allowance of 2.106. So he's actually got £106,000 of headroom. So he could actually, you know, make further contributions, and he wouldn't be able to have any more PCLS, but he would be able to take further benefits as drawdown if he wanted to. It. So that, I just think that usage does cause a bit of confusion, and people could see it and maybe get a little bit alarmed or whatever. It's just the rules. It's the way the legislation statutory instrument is written. So there's not a lot we can do about that. You'll see that from all your scheme administrators. Moving on to somebody who has primary protection with lump sum protection. As I said at the start, lump sum, the primary protection is expressed as a monetary amount rather than a percentage. It's a monetary amount, and that's revalued at the date paid. So whenever you come to take benefits. And until the lifetime allowance exceeds 1.8 million, in terms of how that revaluation will work, effectively it's going to be increased by 20% because it's 1.8 million over 1.5 million. If the lifetime allowance ever exceeds 1.8 million, then it would be that 1.8 million would be replaced by whatever the current lifetime allowance is. It'll always be divided by 1.5 million because it's based on a revaluation from A day. and obviously that was what the lifetime allowance was at A-Day. So as an example here, if you have somebody who had lump sum rights of £500,000 at A-Day, you times that by 1.8 million divided by 1.5, so effectively it's 20% increase, so it's £600,000. So going back to John again, let's imagine he had the same fund value and he had the same protected lifetime allowance, but as well as his primary protection, he also had lump sum protection of £500,000. All that means is that his max PCLS would be calculated differently. It would be that £500,000 increased by 20% effectively to 600,000. So then his drawdown fund would be the difference between the two, because he's still within his protected lifetime allowance. We would have 1.4 million, and the LTA usage reported would be the same. Enhanced protection, you'll be pleased to hear, is a lot simpler. Because you have an unlimited fund value, there's no calculations to do on it. There's no enhancement factors or anything like that. It's really straightforward. They get everything. They don't have any lifetime allowance charge. We still have to report based on the standard lifetime allowance in exactly the same way as we do with primary. If somebody holds PCLS protection with enhanced protection, then they have the percentage on their certificate, and we just use a straightforward percentage of the amount crystallised. So it's unlimited in terms of the fund value. There's no upward value on that. It's just a straightforward percentage. If they don't have any PCLS protection, then it'll be 25%, and again that's going to be based on 1.5 million on that one, so a maximum of 375,000. So that was a little bit simpler. Moving on to what happens with scheme specific lump sum protection then when somebody comes to take this. So there's two elements to this calculation. So you have a monetary amount, because that's how scheme specific lump sum protection is always expressed. So you have that monetary amount, and similar to how we did with the primary protection, you uplift that by 20%. But you also have an additional factor with this. So you have that uplift on the amount held at A-Day, and then you have an additional lump sum, which really is an approximation of 25% of the rights accrued since A-Day. So the basic idea is, yes, you have your A-Day amount, which might be whatever percentage it is. It's expressed as a monetary amount, but you might have you've got your enhanced lump sum, but then anything that you've built up in pensions since A-Day doesn't benefit from the same enhancement, and that just is the straightforward 25%, or approximately. So the way we work this out, the calculation for this additional lump sum, the extra part, is the total amount of the fund that you are crystallising on the date when you take your lump sum. And don't forget, with scheme specific lump sum protection, it is all or nothing. You have to take the whole fund at the same time. You can't do a partial crystallisation. So it's the total amount you're crystallising now, so it's your total fund value less basically your revalued A-Day rights, then divide that all by 4 because it's 25% of it. So I'll give you an example to hopefully make that clearer. Put some numbers on it. So if we have somebody who had a protected lump sum of £50,000 at A-Day when the fund was valued at 100,000, they now in August 2020 have a fund value of £300,000. There's two elements to the equation to working out what the PCLS is. There's the first part, which is your A-Day amount uplifted by 20%. So that's your £50,000 protected lump sum uplifted by 20% to give you £60,000. And then the second part of it is your additional sum, which is meant to represent 25% of everything you've gained since A-Day. So that one you have your £300,000, which is your total fund you're crystallising now, and you deduct from that your A-Day fund revalued in line with changes for the lifetime allowance. So your 100,000 times the current lifetime allowance over the 1.5 million, which was the lifetime allowance at A-Day. So the difference between those two, divide that by 4 for 25%, and that gives you 57,115. And then you add those two together. So the total PCLS available today, you'd be taking £117,115. Moving on to the fixed and individual protections, again, these are relatively straightforward ones. So your fixed protection, when you come to use it, it's just a straightforward whatever your amount is, whether it's 1.8, 1.5 or 1.25, depending on which version of fixed protection you have. pleased to say that the lifetime allowance usage is reported on the protected lifetime allowance. So if somebody's got protection FP12 of 1.8 million, they crystallise £900,000, we will report on it, but they've used 50% of their lifetime allowance, which is far more logical. So yeah, that's fine. And the PCLS will always just be 25% of the funds crystallising up to the protected amount. So that's fairly straightforward, that one. Individual protections, again, very similar to how we treat fixed protection. It's just instead of having 1.8, 1.5 or 1.25, it would be a personalised amount of the lifetime allowance. And we are allowed to report on their usage based on that personalised amount as well. So it'll make sense to them, when you send that out, when we send it out to clients, it'll make sense that they've used X percentage of their own lifetime allowance. And yeah, maximum PCLS 25% of whatever they're crystallising up to that protected amount. So relatively straightforward for those ones. Turning to enhancement factors then. So we talked about earlier about how you get the enhancement factors and how you calculate the relevant amount, and I used this example before. So somebody who had a pension credit of £400,000 in this tax year, you would work out the factor based on the current lifetime allowance, so you get an enhancement factor of 0.38. If they then wanted to crystallise immediately, they wanted to take their benefits, you would apply that enhancement factor to this year's lifetime allowance. And so they would have a lifetime allowance of 1,480,878. So if they're doing it a few years in the future, it'll just be against whatever the standard lifetime allowance is at that time. What you can see on this, that they do get a little bit of a bonus because of the way the rounding works, so they actually get a lifetime allowance of increase of slightly more than the actual transfer of the credit that's come in for them. So they do get a slight bonus because the way the rounding works on that one. Right, I'm going to finish off now with looking at some of the interactions between different types of protections on enhancement factors and how this will work in combination. First one is enhanced with dormant primary protection, which I say was pretty common for anybody who had pension funds above 1.5 million at a day. I think most scenarios advisors would have advised their clients to take enhanced with dormant. So this example I've got for you, they had an A-day fund value of 2 million with 600,000 PCLS. So in those circumstances, they would have had enhanced protection with their PCLS would be represented as percentage, so that's 30%. And they could have dormant primary protection with a PCLS expressed in monetary terms, so £600,000. And the primary protection factor based on a £2 million fund, you divide that by the 1.5 million, the protection factor would have been 0.34. If they are now coming to take benefits, their personal LTA this year would be £2,412,000. So normally enhanced protection would be your best option. I say it's the top trump, so you can never have an LTA charged with enhanced protection. But there are circumstances, because the difference in the way the PCLS is treated, that there are circumstances where you may be better off using the primary protection, but it's really only if your fund hasn't done very well. So we've got the example here on this table where we've got different fund values when they're coming to crystallise. So what you'll notice is that the primary PCLS doesn't change no matter what the fund value is across the top, because the way primary protection works, and you just have this uplift of 20%, PCLS is always going to be £720,000, whereas if you have enhanced protection, it's 30% of whatever you're crystallising. So if your fund value is only 2.2 million, then your enhanced PCLS is only 660,000, whereas under primary it would be £720,000. So in those circumstances, you would be better off revoking the enhanced protection and taking primary, so you could get the enhanced level of PCLS. But that's because your fund value of 2.2 million is still below your primary protected lifetime allowance of 2.412. So, you know, you're still not going to have a lifetime allowance charge, and you can get more PCLS. Obviously, with that as well, you could have the option of, you know, topping up the pension a bit with further contributions, which in itself would revoke the enhanced. You could get tax relief on it if you've got sufficient annual allowance. You could top those up. You wouldn't be able to get any, you wouldn't be able to increase your PCLS by doing that if you're using the primary, but you would be able to get more into the pension without an LTA charge if that was appropriate. Obviously the same again, still better with primary if your fund's 2.3 million. 2.4 million is kind of your break-even point where you've got your PCLS is the same either way. And obviously once your fund grows above that, once it goes above that level, first of all, your enhanced protection is going to give you more PCLS, and obviously you wouldn't want to do the primary at that point once you're over your personal lifetime allowance, because you can start hitting lifetime allowance charges. But it's just to show really that there are circumstances, depending on fund values, fund performance, where it might be better to use the primary than the enhanced. It can happen, so just to be aware of that one. In terms of how you revoke the enhanced protection, obviously you can do it by contribution, but you can just write to HMRC as well. It's not necessary to make a contribution. You can just inform them, and that will work as well. So it's very common to have dormant primary to enhanced protection. You can also have dormant individual protection, usually to fixed. So as an example here, to have somebody who had fixed protection 2014 at 1.5 million, they could have dormant individual protection, for example, at 1.4 million. The criteria for that was for individual protection 14 was a fund value between 1.25 and 1.5 million. So this would fall into it. If the fund value dropped below 1.4 million, then if you have individual protection, you can contribute to top it back up to that level prior to crystallising. The way I think of individual protection when it's dormant to fixed is really, it's the insurance against your fund going down. So if your fund is going upwards from, say, the date you took out the protection, the fund value was 1.4 million. As long as your fund's going in the right direction, you're going to be better off with the fixed protection because it's at a higher level. But if for whatever reason, you know, your funds do drop, at least individual protection allows you to make the contributions back up to that existing fund level. Whereas obviously any contribution you make will invalidate your fixed protection, but the individual, say, just gives you that to say it's an insurance policy really. On that one, gives you better than you dropping all the way back down to a standard lifetime allowance. It is also possible to have, for somebody that had scheme-specific lump sum protection at a day, to then later date take out fixed or individual protection. So you couldn't have scheme-specific. It is a standalone. So if you had it back at a day, you would either have that or you'd have your primary or enhanced with a lump sum. You couldn't use both. But somebody, let's say, that had that back from 2006, that scheme-specific lump sum protection can still take out one of the newer forms of protection. And this calculation is exactly the same we showed earlier, where your a-day protected amount, your scheme-specific protected amount, is just uplifted by 20%. And then you have this calculation, which is the approximation of 25% of your rights accrued since a-day. If you have fixed or individual protection, all that happens is in that equation there, then you replace the current lifetime allowance with the appropriate level of protection. So you would protect it with, 1.1, 1.5, 1.25, or the personalised protection as appropriate. So I've got an example to explain that one. Here we have Tom. Now Tom has got a £1.7 million pension fund, and he has scheme-specific, I can't get the words out, scheme-specific lump sum protection of £300,000, and his 8-day benefits were £800,000. And he's got fixed protection 2012, so that would be the £1.8 million level. So when we work out what his pension commencement lump sum can be, he would still have his a-day amount of £300,000 uplifted by 20% to £360,000. That would be the same whether or not he had the whether he had the fixed protection. The difference is when we work out the additional factor, the additional sum in relation to his post-A-Day benefits. So here we would use the 1.7 million, which is his total fund, pension fund that he's crystallising now, because you have to crystallise everything at once. You can't do a partial, it has to be everything. And you deduct from that his A-Day benefits of £800,000, total A-Day fund. But the revaluation then is based on his protected level of 1.8 million divided by the A-Day level of 1.5 million rather than the current. So that will make quite a big difference to the PCLS he can take out. So the difference between those two divided by 4 gives him an additional lump sum in relation to his post A-Day benefits of £185,000. So his total PCLS will be £545,000. A few more just like little quirks with the interactions of protection. There are circumstances where you might have even wanted to revoke enhanced protection fixed because the way the rules changed worked. So an example, if somebody had enhanced protection and a fund value back in April 2012 of 1.7 million, if they use their enhanced protection to crystallise in 2012-13, their maximum PCLS would have been 25% of 1.5 million, 375,000, sorry. But if they'd actually revoke enhanced protection and taken out fixed protection, because they could get fixed protection at that point at 1.8 million and crystallised it that year, then their maximum PCLS would have gone up to £450,000. I'm not sure that was an intentional when they changed the rules, but it's just because they didn't underpin the PCLS amount for enhanced protection to 1.8 million. They've only done it to 1.5 million. So, you know, it just has produced some anomalies over time. Okay, moving on to enhancement factor combinations. Yeah, it's possible to have more than one enhancement factor and they can all sort of work together. Got a case study, I think it's probably the easiest way of explaining it. We've got Jess here who's 50. I think it's fair to say she's had an interesting life. She started off, probably like most of us, working in the UK, as a relevant UK individual, paying into a UK pension scheme. Very straightforward. She then moved abroad with her global employer, and she was working abroad, but she still had contributions going to a UK pension scheme. But she became a relevant overseas individual and she was paid in a country of residence. So she ceased to be a UK relevant individual, having moved abroad and become not resident for tax purposes in the UK, but there may still have been contributions maybe paid by her employer going into the UK scheme. She then changed jobs and got employed locally in her country of residence. So she's no longer in that UK scheme, but she joined her employer's scheme in the country she was working. So she joined a cure-op scheme in the country of residence. She then came back to the UK and decided to transfer that cure-ops back into the UK scheme to have everything over here in the UK system. And then just to cap it all off, she got divorced and got a pension credit. So if we look at this, she would be entitled to a non-residence factor because she had a UK pension scheme, but there was money going into that on her behalf when she wasn't a UK relevant individual on that. She then had a ROPS transfer. So she transferred a cure-ops into a UK scheme, so you can have a ROPS transfer factor. And if she got pension credit on divorce, if her spouse was a bit older and he'd already started taking benefits, so those were crystallised benefits, which came across to her, then crystallised since A-Day, then the pension credit factor, she could apply for that as well. So it's quite complicated, 3 different types in there. Of course, it is actually possible for people to have multiples of each type as well. So there's not really a limit on how many enhancement factors somebody could potentially have. Probably fairly unusual to have lots of them, but it is theoretically possible. The good news is that you simply add all those factors together and apply it to whatever the relevant lifetime allowance is. So, for example, if she had a non-resident factor of 0.2, a ROPS factor of 0.3, a pension credit factor of 0.25, no other protection, takes benefits this year. Okay, I just realised she's 50, she probably can't just yet, but if she was a little bit older, or she waited a few years, it would be, the principle would be that it's, you know, the lifetime allowance relevant at the time you take benefits times, you know, 1 point, and then you add your factor in. So we give her a personal lifetime allowance of here of £1,877,925. You can also have an enhancement factors and already hold another type of protection. One you can't have though is with enhanced protection, because you can't enhance protection. It's already the top trumps, you can't have any more on that. But you can have an enhancement factors in combination with primary protection, fixed protection, or individual protections, any of those. That enhancement factor is then applied to the relevant lifetime allowance. Yeah, if you have an enhancement factor and primary protection, you add your primary factor and your enhanced factor together and then apply it as applicable. And you use the relevant lifetime allowance to apply it to. So if you have somebody who have a lifetime allowance enhancement factor of 0.25 and they have fixed protection 16, then you would apply that 0.25 to their fixed protection level of 1.25 million. So they would have a personal lifetime allowance of 1.562500 million on there. Finally, loss of protection then. Enhanced protection and fixed protection can be revoked or lost. So most commonly will be somebody makes a contribution, often without realising. So there were issues with auto enrolment. So people need to make sure, particularly if they change job, they tell their employer that they've got one of these protections so they can not auto enrol them. They can be revoked at any time, but say by notifying HMRC. If it is lost, then there is a 90-day period in which to inform HMRC of this. And the rules of this are slightly different. In relation to enhanced protection or fixed protection 2012, it is just a straight 90 days from the date the protection is lost, so it would be the date of the contribution. For the later versions, so FP 14 and 16, so it's a bit more lenient in the rules, in the fact that you have 90 days with, you have to tell HMRC within 90 days of the day on which they could first reasonably be expected to have known they'd lost their protection. So, you know, if a client has lost it through auto enrolment and they didn't realise, you know, there might be some leeway for them notifying HMRC within 90 days of when they first realised, rather than if it's the older forms of protection, it's just a straight 90 days. If you don't do that, there is liable for penalties up to £300 for failing to notify, and daily penalties of up to £60 per day after the initial penalty is raised. So particularly harsh for somebody who's lost it accidentally. They've already probably lost a bit by losing the protection, then they can lose some more by not telling HMRC. So primary protection and individual protection can only be lost on divorce. They can be reduced or lost, but as I mentioned earlier, I'm going to talk about that one in my next webinar, which will be in a couple of weeks' time, when I look at divorce. So last slide, key points from today then. Remember that fixed protection and individual protection 16 applications are still open. There is no deadline on those. So, you know, if you get new clients come to you that's applicable for, then don't forget they're there. You can still make late applications for enhanced and primary. It seems like a long time ago, I know, but there's limited circumstances, and again, it's not one you're going to come across all the time, but you know, it could happen that you could have a new client come to you where they've maybe not had the advice they should have done previously. When it comes to doing your calculations, we have this underpinned lifetime allowance for primary protection. So whatever your enhancement factor is for primary, you apply it to 1.8 million. When you're working out maximum PCLS for enhanced and primary protection where they don't have lump sum protection, then you're always working off 1.5 million. And finally, the lifetime reporting doesn't always match the personal lifetime allowance for the older forms of protection. So you know, don't be alarmed, and obviously we just need to take a bit of time to explain to your client what it means and then not to worry about it if it doesn't match up with their expectations when it tells them they've used more than 100% of their lifetime allowance. It's not actually reflecting their personal lifetime allowance if they do have primary protection. So that is all from me. So thank you very much for those of you that have listened to the end. If you do have any questions relating to this, then you please do get in touch. After the session, my colleague will be sending you out a copy of the slides. They'll also connect you with your CPD certificates, and there'll be an opportunity then for you to ask any questions. If you do send those through to us, then either myself or one of my colleagues will do our best to answer them and come back to you. But that's all from me for today, so thank you very much.